presentation on the latest tax legislation called Secure Act 2.0, signed into law by President Biden on December 29th of 2022. This legislation, it was part of a comprehensive consolidated appropriations act, and it was unsure to the last minute as to whether it would be included in the comprehensive legislation. Most of you remember legislation actually has more significant provisions than the original act, including a couple that take on a huge importance. So over the next hour, my colleague Sarah Broder and I are going to walk you through the changes. Of course, we are only days ahead of you in reviewing the legislation, but we've had to go to the full text on many of these provisions in order to get a grasp on what Congress was saying. Now, there are two provisions that do not directly relate to retirement plans. They relate to other tax provisions affecting individuals. So we'll lead off with those, and everything else will be related to retirement plans. Now, one thing that is particularly interesting about the act, and it's something that I had not seen, and my memory goes back to the Tax Reform Act of 1976, and I don't recall seeing this diversity of effective dates of the various provisions, particularly on a single subject related to retirement plans. So as we go throughout the program, make a note or a mental note of the various effective dates. Anyway, the two provisions which don't directly relate to retirement plans, the legislation allows first responders, police, firefighters, and others who have service-connected disability income, which historically has been tax-free until retirement age, to continue to be tax-free when they reach retirement age. This seems like a simple provision, but in practice, I know it's going to be quite difficult, and it may depend upon the terms of the individual plan set up by the jurisdiction. So be careful here. This provision is effective in 2027. The hottest, and I'll put that word in quotation marks, tax shelter in recent years has been conservation easements, and a very favorable to the investor provision allows, after the effective date, that defects in conservation easements may be corrected for contributions made after the effective date. You can't go backwards and correct things. And interestingly, just yesterday, the U.S. Supreme Court refused to take on a case involving a defect in the easement and let stand a pro-IRS decision where the appellate courts were deeply divided. And I think, Sarah, you're going to talk about automatic enrollment.
Yes. So the first section of Secure 2.0, section 101, expands enrollment in 401k and 403b plans. So instead of employees who become eligible being required to opt into a 401k or 403b plan, they're going to be automatically enrolled. Of course, the employee still has the ability to opt out if they want to, but it requires more of an affirmative step from the employee. And of course, Congress is thinking and hoping that this will encourage people to get used to the deductions in their paycheck and decide not to opt out, and to maintain enrollment in a 401k or 403b and increase their retirement savings. Remains to be seen whether that will actually work, but that is the hope. So initial enrollment for this, once they're automatically enrolled, it needs to be at least 3% of compensation that's deferred into these accounts, but it can't exceed 10%. And that amount is going to increase by 1% each year thereafter until it reaches either 10%, but not more than 15%. Essentially, it's 4 years of an automatic increase in employees' contributions. Current plans that were in place before the enactment of Secure 2.0, so before December 29th of 2022, are grandfathered. So they do not have to automatically enroll their employees, but any plan that's established after the date of enactment needs to start the automatic enrollment of employees beginning in 2025. This provision does not apply to small businesses, so 10 employees or fewer. Doesn't apply to new businesses that have been around for 3 years or less, church plans, and governmental plans.
The legislation increases what had been a partial credit for setting up a small employer plan. Effective 2023 tax years, a smaller company, and that is defined as a company with less than 100 employees, for certain purposes of this provision, and less than 50 employees for other purposes. When they create a plan, up to 100% of the first $5,000 of costs, administrative costs of any type, in the first 3 years will be deductible. That applies for employers with less than 50 employees, and then for all plans except defined benefit plans, which we don't see a lot of anymore, an additional credit that is tied to employer contributions of up to $1,000 per employee. Don't take into account anyone making over $100,000 indexed. There is an additional credit, and the applicable percentage, which starts out in regard to the additional credit at 100% for years 1 and 2, drops by 25% in years 3, 4, and 5. It is a percentage of employer contributions up to $1,000 per employee. And the concept behind this, and the concept of many of the provisions of this legislation, is to encourage savings by lower income and lower middle income individuals. Now, interestingly, we have a federal match in certain cases. There has been a non-refundable credit for lower income individuals who make contributions to retirement plans, IRAs, and ABLE accounts. This will continue through 2026. In 2027, it will be replaced with a federal match, not applicable to ABLE accounts, but to company retirement plans and IRAs, the federal government will match 50% of a business's retirement plan. Let me restate that individual contributions to a business's retirement plan or individual contributions to an IRA, the 50% is applied on up to $2,000 of individual contributions. It is intended more for lower income individuals, as you see the phase out levels in your outline. The dependents and students who are non-dependents are not eligible for this federal match.
We have a question online. It says,
Real loud, please.
is the 401k exception for businesses created before 12/30/2022 or businesses with plans where the plan was created before 12/30/2022? So
If the plan was created before the effective date of the legislation, automatic enrollment is not required. If it was created after the effective date of the legislation, it is required, but it is not required until you hit, what is it?
2025.
Okay. 403B plans, multiple employers can get together to create a single 403B plan effective 2023 plan years. Now, here is an important one that has already taken effect, and that is a rise again in the age when you must commence minimum distributions from an employer plan or IRA. The original Secure Act took it from 70.5 to 72. It goes up this year, 2023. If you were not age 72 in 2022, you can wait one extra year and you must commence distributions now for the year in which you turn age 73. That grace period of 3 months into the following year for that initial distribution is still effective, and also effective in regard to employer plans. If you are less than a 5% owner, you do not need to commence distributions even at age 73 if you continue to work. Now, one technique that we have recommended and a number of clients have followed our guidance is in the year prior to turning the relevant age, now 73, you cut your ownership interest to below 5%. And then you can delay distributions as long as you're working. There is no guidance. Can you work 100 hours a year? And no guidance whatsoever. Apparently, as long as you are performing bona fide services, you do not need to take. And Sarah, I think the floor is yours.
Sure. So the next provision, section 108 of the Secure 2.0 Act, indexes catch-up contributions for IRAs. So as many of you know, if you're age 50 or older, you can put an extra $1,000 in your IRA as a catch-up contribution, which has been $1,000 for many years now. And now it is going to be indexed for inflation, and that's starting in 2024. So it'll be $1,000 this year, and then in 2024, it'll be indexed for inflation. The next section, section 109 of Secure 2.0, another theme of many of these provisions relates to catch-up contributions. This one is about employer-sponsored plan catch-up contributions. So right now, an employee over age 50 can make a $7,500 catch-up contribution to these plans. It's $3,500 for simple plans. But Secure 2.0 or changes it for certain age groups. So if your age is 60 to 63, it increases the catch-up to a greater of $10,000 or 50% more than the catch-up amount is going to be in 2025. And that's going to be $5,000 for simple plans.
The wording here is not best. I will admit I wrote it where it says 50% of the regular catch-up amount. It should say 50% more than the regular catch-up amount. Sorry.
And then that's going to be indexed for inflation as well, starting in 2026. So these changes for the ages between 60 and 63 take effect in 2025. But note later, this is going to be all the way at the end of the presentation, there's another provision relating to catch-ups that might cut many people out of this ability to put any catch-ups into a pre-tax account. So the next section, section 110 of Secure 2.0 is, goes with the theme recently of trying to help out borrowers of student loans. This allows for employers to match an employee contribution, what would have been a contribution to their retirement account, but instead is a payment on their student loan balance. So the theory behind this is that many borrowers have to choose between saving for retirement and paying off their student loans, but many don't have the ability to do both. And so if the employee's student pays off their student loans, then the employer can match that amount into their deferred retirement account. The interesting point about this one is that employees can self-certify that they've made this payment. The employers don't have the requirement to verify this. And a qualified student loan payment is also defined very broadly. So it doesn't have to be a federal loan. It doesn't have to be anything that's specifically a loan specific for education. It just has to be taken out by the borrower to pay for education. Sure, there'll be additional guidance at some point, hopefully, that narrows that a little bit, or at least explains that a little bit, but I'm sure we'll find out. And this also, there's a built-in mechanism so that this employer matching doesn't mess up any non-discrimination testing for the plan itself. This applies to 401ks, 403bs, simple IRAs, and 457bs. And it starts for contributions made in 2024 and thereafter. Section 111 of Secure 2.0, this relates to multi-employer plans. So small employers, it's really fixing a technical glitch in the law. So right now, a small employer that's joining a multi-employer plan can take a tax credit for 3 years for joining this plan, but it's 3 years from the date that the multi-employer plan was established. So if the small employer gets in a year or two after the multi-employer plan is started, they can't take the credit for very long or at all. Now Secure 2.0 fixes it so that the small employer can take the credit for 3 years from the date that they join the multi-employer plan, regardless of how long the multi-employer plan has been in place. So this might require the filing of amended returns to take the credit. It is effective retroactively. I think it's the only provision that's effective retroactively for taxable years beginning after December 31st of 2019. Section 112 of the Secure 2.0 Act, this relates to military spouses. And I think the theory behind this is pretty clear. Military spouses often are, they're moving every 3 years usually. And so they're never at an employer long enough to become eligible to save for retirement. So the goal of this provision is to make military spouses eligible quicker. So Secure 2.0 provides a tax credit to small employers to make military spouses eligible what they call immediately, which is within 2 months, I think 2 months after they start, and immediate vesting as well, so that they can, military spouse can take the plan with them. It also accelerates matching and non-elective contribution eligibility for military spouses. So what non-military spouses would be eligible to receive with, after 2 years of service in that plan, military spouses would be able to receive automatic or immediately. The tax credit is a maximum of $500 per military spouse for 3 years. This does not apply to highly compensated employees. And this is another example of the self-certification. So here, military spouses can certify that they are a military spouse, and they don't have to provide any proof other than that, and the employer doesn't need to verify. This applies, like I said, to small employers, which is 100 employees or less, or fewer, I should say, and effective for taxable years beginning after just the date of enactment. So it's 2023 and going forward. Section 113 of Secure 2.0 allows employers to provide de minimis financial incentives to their employees to join the employer-sponsored retirement plan. So it's a 401k or a 403b that these apply to. And the goal, of course, is to boost participation in the workplace retirement plan. Again, remains to be seen whether that's going to be effective. Also remains to be seen what de minimis means. There's really no guidance whatsoever on that. 25, 50, 100, I don't know. But the idea is, gift cards and things like that.
What's funny is that IRS has insisted in regard to employee rewards, whether for service or for accomplishments, that you can't really use gift cards anymore in a tax-free manner. And here we have Congress encouraging gift cards for lower income people participating in a retirement plan. Okay, one additional remark, by the way, back on the change to age 73 for minimum distributions. The age 73 is scheduled to jump to age 75 in 10 years. The legislation says age 75 in 2033. Now, I have seen several outlines talk about somewhere in between there's a jump to age 74, but I have looked at the statute and it isn't there. I think I saw it in some earlier versions in 2022. So keep your eyes open. I think it stays age 73 for a decade, and in 2033, it jumps from 73 to 75. So ESOPs traditionally have been a tool that C corporations have utilized in when owners have reached the point where they're considering retirement and they don't have one or two key people that want to acquire, and they don't have outsiders interested, so they sell to a broader base of employees through an ESOP. It used not to be permitted in the case of an S corporation. For some years, S corporations have been able to utilize an ESOP, but there was no deferral of gain on the part of the owner for amounts realized on the sale of stock. And now up to the gain on up to 10% of the amount realized on a sale of stock to an ESOP by an S corporation can be deferred effective 2027. Now, here's one of a number of provisions that makes this law, makes the tax law in general so complicated, regardless of your politics, is you look at these provisions as we go over them. Some of them offer fairly insubstantial benefits, although to a lower income individual, it seems substantial, but boy, does it complicate the retirement plan law. I taught the course in retirement plans at American University for 20 years, back in the 80s and 90s. And it was complicated then. And now we get into all these little nuances and variations, and it has become even more complex. So, one emergency withdrawal per year up to $1,000 from a retirement plan or IRA will be permitted effective 2024. No new borrowing for 3 years unless either the borrowed amount is repaid or there have been new employer and or employee contributions in excess of the borrowed amount, which will be likely in many cases. The legislation allows employers to make additional contributions to a simple plan beyond the current choices that are utilized, where an employer either puts in 2% of compensation for everybody who meets eligibility, or 3% of compensation for those who have made elective deferrals. But additional amounts can go in by the employer in a uniform manner up to the lesser of 10% of compensation for $5,000 index.
For the online folks, we have the code words for.
Oh, yeah, we've got some code words, and I should have gotten started by now. Do we have to do 3 or 4? 3? Okay, so the first code word is Thomas, the name Thomas, THOMAS. We'll have the other 2 code words later in the presentation.
Okay, so along the theme of catch-up contributions, here's another provision relating to them, section 117 of Secure 2.0. This applies to simple IRAs and simple 401ks. So these are for small employers, 100 employees or fewer. And for simple plans, recall that these are employers, these plans require employers to make matching contributions on the first 3% of compensation deferred, or an automatic 2%, as David just said. So the current law is that there's a regular annual limit of contributions of 14,000, I think that was last year, and a catch up of 3,000 for age 50 and older. Secure 2.0 kind of bifurcates the change in the law. So if you have an employer that has a maximum of 25 employees, that is going to be a $14,000 annual limit plus $3,000 catch up. That's going to be increased by 10% in the first year that the change is effective, which is 2024. For employers that have 26 to 100 employees, they can provide a higher limit and catch up, but only if the employer provides 4% matching instead of, or 3% of compensation instead of the 3% and 2%. Again, this becomes effective in 2024. Section 118 of Secure 2.0 allows employers of domestic employees, so think of nannies as a great example, to provide SEP IRAs to those employees. It's effective for taxable years after the date of enactment, which was December 29th of 2022.
Wonder how many people they predict who employ household workers and who actually provide the workers with W-2s are going to create SEPs.
that was my next point, was that they have to get W-2s. Yeah, no, that's a good point. So I am curious how that's gonna work out, but, the next section 121 of Secure 2.0, this creates two new kinds of retirement plan, employer-sponsored retirement plans, with similar limits to an IRA for contributions. So the idea behind this one is that 401ks and 403bs are expensive to administer, they're expensive to start, which means that a lot of employers just don't have them. So this Secure 2.0 establishes these two new kinds of retirement plans. We have one called a starter 401k and then a safe harbor 403b, and they're both deferral only plans. So the employer is not making any contributions. The employer can establish these only if they do not have an existing employer-sponsored plan. Of course, there's exceptions to that, but generally speaking, that's the case. And it's a default enrollment for employees between 3% and 15% of compensation deferred. And like I said, the same annual contribution limits as IRAs. And this is effective for taxable years starting in 2024.
Note, and this is very important, and I'm not sure whether we've made this clear or not. And this applies to the to a regular 401k plan set up by an employer after the effective date when the provision takes effect in 2025, is you are setting the employee up initially with, say, a 3% elective deferral. The employee is free to change it or opt out of doing an elective deferral. But the starting point, if the employee does nothing at the commencement of their participation, is that 3% in my example.
The next section, section 125 of Secure 2.0, reduces, this is modified slightly, in provision that was included in Secure 1.0. So it's for long-term part-time workers, and Secure 1.0 allowed them to participate in employer-sponsored retirement plans, with either 1 year of service with 1,000 hours, or 3 consecutive years at 500 hours of service per year. And Secure 2.0 just reduces that 3-year rule to 2 years. So now it's 2 years of consecutive 500 hours of service. Applies to 401ks and 403bs that are governed by ERISA. And it's effective for plan years beginning after December 31st of 2024. So essentially in 2025. Next section, section 126 of Secure 2.0 is relating to 529 plans. So the idea behind this one, as I've seen it, is that people shouldn't be penalized for over saving for college. You know, if you put money into a 529 and you end up, you know, your kid gets a scholarship and they don't need that money, that's great. But to take that money out, they shouldn't incur taxes and penalties. So this enables the beneficiary of that 529 to roll over leftover money from their 529 into a Roth IRA. There's, of course, a lot of conditions to be able to do this. There's a maximum rollover over the beneficiary's lifetime of $35,000 from all accounts that the beneficiary has. So if there's, you know, grandparents set up account for them, parents set up account for them, it's $35,000 over all of those accounts. And it is, the beneficiary must have been a beneficiary of the 529 for at least 15 years. So of course, the purpose of setting up the 529 actually had to be to save for college. And it's subject to the Roth IRA annual contribution limits when you're rolling it over from the 529 to the Roth IRA. And that starts for plan years starting in 2024. Section 127 of Secure 2.0. This is another emergency savings provision. This is for non-highly compensated employees. And it allows an employer to provide an emergency savings account within their employer-sponsored retirement plan. So employers have the option to do this, it's not required, but it can be, the employer can automatically opt their employees into it. And it would be a maximum of 3% of their salary, but this emergency savings account can never have more than $2,500 in it. The employer can reduce that amount, but it can't exceed that amount. Any additional contributions that the employee makes to their emergency savings account would be put into a Roth account. And the employee can withdraw from this emergency account up to 4 times per year without incurring any fees or charges. And these contributions to the emergency account also qualify the employee for employer matching. And the employee can take it with them. So if they terminate employment, the employee can take it either as cash or it can be rolled into a Roth account. And this applies to distributions made in 2024 on.
We had a question online about that. It says, do you know if the 529 beneficiary must have earned income in the year the 529 rollover to the Roth IRA is made?
I don't think there's any.
Yeah, I don't think so either.
Yeah.
Okay, there's a couple of provisions affecting annuities. The legislation liberalizes the ability to put certain increases in the amount of the annuity, which typically would be an even amount for the rest of your life or a joint life, and a very complex provision. There is an ability to keep up with cost of living by building in certain increases in the amount of the annuity. The legislation allows bifurcation when a retirement account holds both an annuity and other assets to determine separately the minimum distribution on the annuity and the minimum distribution on other assets. Now, suppose there is an overpayment to a retiree and the employer wants it back. Well, if it's the government that wants it back on excess Social Security, they want it back now. In the case of an employer, the law will give a retiree the right to repay an excess payment over 10 years and potentially longer, because there can be no more than a 10% reduction in normal payments to effectuate the payback. The annuity rules were effective 2022 on the liberalization, the bifurcation after the effective date, and the overpayments after the effective date. Let's go ahead and do our second word for those of you who are virtual. And the name or keyword is Sprig, S-P like Paul, R-I-G-G. And some of you, and don't shout it out, those who are in the room, may be able to guess what the third word is, but we're not going to give that away yet. The legislation cut the very tough penalty for failure to take a timely minimum distribution from 50% to 25% and cut it further to 10%. In the case of the IRAs only, I don't know the reasoning here. If you fail to take a timely minimum distribution from an IRA and you correct it by the earlier of the deficiency notice date of assessment or 2 years after the end of the applicable year, the penalty is 10% instead of 25%. The legislation requires DOL within 2 years from enactment to create a national database of unclaimed retirement plan benefits. When a retirement plan terminates, an employer is supposed to distribute to all participants, but some participants have terminated employment, left no address. An employer is obligated to use best efforts to track them down. And if they are unsuccessful, it is in Maryland paid over to Unclaimed Property Division of the state of Maryland, because people move outside the state. There will be a database by 2025 setting forth unclaimed retirement plan benefits. When an employee leaves and they have a very small amount in their retirement plan, say under $1,000, the employer is permitted to cut a check to the employee irrespective of the employee's wishes. That is unchanged under Secure 2.0. Under prior law, if the balance was between $1,000 and $5,000, the employer was authorized to set up an IRA in the employee's name in the absence of instructions from the employee. And that amount has been increased from $5,000 to $7,000 effective 2024. If you're over that dollar threshold, the employer must hold on to that money and try tracking the person down, and ultimately can turn it over to unclaimed property. And Sarah, I think the floor is yours again.
So section 305 of Secure 2.0, this allows more types of errors in retirement plan administration by employers to be self-corrected rather than having to go through IRS. There's a lot of details on this provision that we don't really have time to go through, but the goal is probably to reduce the burden on IRS to deal with these things. And it covers many more types of plans that are allowed to self-correct, and it also allows for more significant errors to be corrected. A good example is a lot of errors happen with plan loans. And so this provision allows plan loan errors for the most part to be self-corrected. The self-correction needs to be within a reasonable amount of time from discovering the error. Unclear what that amount is, but I'm sure we'll find out. Section 307 of the Secure 2.0. This indexes the annual charitable donation you can make from an IRA each year. So it's $100,000, and that's going to be now indexed for inflation. It also permits a one-time $50,000 payment to a split interest entity like a charitable remainder trust. This is also going to be indexed for inflation, so it's $50,000 to start, but will be indexed, I believe, starting this year or next year. I'm sorry. It came into effect date of enactment, which was December 29th, 2022.
And we have a provision that permits a penalty-free distribution to someone who is in a disaster area as declared by the president and has been adversely affected. It is not sufficient to just reside in a disaster area. You must be affected by the disaster, in which case within 180 days of the declaration, you can withdraw up to $22,000. This provision is retroactive. Also, the individual gets to pick up the income ratably over a 3-year period at his or her election. And if you prefer not to take a distribution, you have the ability to borrow up to twice the normal permitted borrowing. The penalty on withdrawal of excess contributions to an IRA is eliminated. Right now, if you put money in an IRA and you take it out after the due date of the return, it is treated as being subject to a 6% penalty for excess contributions. And that penalty in making corrective distributions, taking out the excess amount plus the deemed earnings on that, is eliminated, and it is retroactive for open periods. Defined contribution plans, everything except defined benefit plans, are permitted to distribute up to $2,500 as indexed, penalty free for the payment of premiums on long-term care contracts. That provision takes effect 2 years after enactment, and it is only penalty free in the case of certain, you can do it, but it is not free of penalty unless the coverage is deemed to be high quality as determined by regulations. Private sector firefighters will be allowed to take distributions in any at age 50 as opposed to age 55 without penalty, effective as of the date of enactment. It was already permitted for firefighters in the public sector. And employers can rely on employee certification of hardship. If you want a hardship distribution, employers had to make certain inquiries previously. Effective 2023 plan years, you can self-report the hardship. And very significant, back on excess contributions and failure to take minimum distributions. These are reported on a 5329, and the law said if you did not include a 5329 with the return, there was an unlimited statute of limitations. Even if your tax return would generally have a 3-year statute of limitations. Well, on minimum distribution failures, notwithstanding the failure to file Form 5329, it will be a 3-year statute of limitations. And on retrieval of excess contributions, a 6-year statute of limitations. And let me give the last code word before I turn it over to Sarah. And that word is Wooton, WOOTTON. Our office is on Wooton Parkway. Both my sons went to Wooton High School, and it is Thomas Sprigg Wooten is the name of the school, at least at present, but because Mr. Wooten was an enslaver, this is one of the schools where the names may be changed in succeeding years, and presumably the name of the road on which our office sits. Sarah.
Section 314 of Secure 2.0. This kind of goes along the same lines of emergency withdrawals from retirement accounts. This allows victims of abuse to withdraw from a retirement plan penalty-free. Note, it doesn't say tax-free, it just says penalty-free. And an employee, if the employee self-certifies that they've been a victim of domestic abuse, they can withdraw the lesser of $10,000, which is going to be indexed for inflation, or 50% of their account balance without the 10% penalty. However, I said that they're going to have to pay income taxes when they take the money out. But if the employee can repay that money within 3 years, they will be refunded for the income taxes that they paid. And this is effective for distributions made after December 31st of this year.
And we have a couple interesting provisions here. Historically, you had to amend, if amendments were needed, you had to amend your retirement plan by the last day of the year, just as until very recently, you had to create a retirement plan other than a SEP by the last day of the year. A year or two ago, the rule changed. You can create any retirement plan until the extended due date of the return. This legislation allows plan amendments increasing participant benefits, not decreasing, increasing participant benefits to be made until the extended due date of the tax return effective 2024 plan years. And if you have an unincorporated business with no employees, you're basically a Schedule C or a single owner LLC, you will be permitted effective 2023 tax years to make elective deferrals for the initial year of a 401k plan until the original due date of the return, April 15th, not the extended due date of the return. So if you set up a single owner 401k, not only can you do the entity contribution after December 31, that can be done until the extended due date of the employer return, essentially October 15. But you can also do elective deferrals up to April 15. The legislation clarifies that if you have an IRA that engages in a prohibited transaction, and I deal with that semi-regularly, it does not disqualify other IRAs of the individual. That's really a clarification. It says it's effective 2023, but I don't consider this a new provision. And the legislation eliminates the requirement of minimum distributions from a Roth 401k prior to the death of the account holder. That takes effect in 2024. If you remember, if you have a Roth IRA, you do not need to take out amounts during the lifetime of the account holder and the lifetime of the spouse if it is rolled over. And the same Roth IRA rules will apply to Roth 401k. You do not need to take them out at age 73. You don't need to commence distributions. The legislation allows a terminally ill employee with death expected within 84 months after the date of enactment to receive an early distribution from an employer plan, not an IRA. That's one of the things that makes it confusing. Some provisions applicable to both employer plans and IRAs, other provisions just employer plans, still other provisions just IRAs. It permits a surviving spouse who is the sole designated beneficiary to be treated as the employee effective 2024. I have agonized over the significance of this provision, and it isn't totally clear. Sarah and I believe that it does not require you to do a rollover in order to be treated as the employee and to be able to designate your own beneficiary and to spread it out over that longer period of time with the deemed beneficiary 10 years younger than you without actually doing a rollover. Stay tuned for clarification there. The legislation makes indefinite by law the current administrative policy that allows corrections to be made within 9.5 months of the end of the plan year. And it requires that all plans be amended by the end of 2025 plan years to have the language consistent with Secure 1.0, Secure 2.0, the CARES Act, and all other retirement plan changes in the law. Simple IRAs may accept Roth contributions effective 2023 years, and the hardship rules for 403B will parallel those for 401K effective 2024 plan years. We're down to our last several, Sarah.
So section 603 of Secure 2.0, I alluded to this way at the beginning. This applies to catch-ups again, but this is catch-ups to qualified retirement plans. Right now, they can be either pre-tax or they can be Roth. But this provision says they have to be Roth contributions if the employee is earning compensation over $145,000 per year, which will be indexed. I'm sorry, it's $145,000 or more, which will be indexed for inflation. And this is effective for taxable years beginning in 2024.
That's a real important provision because a lot of people over 50 are doing this added amount, and most are doing it in pre-tax dollars. 2023 will be the last year that this can be done in pre-tax dollars.
Section 604 of Secure 2.0, this allows employer matches and employer contributions to be on a Roth basis. Right now, employers can match on a pre-tax basis, but in effective on date of enactment, so effective right now, participants can now have the option of taking a match in pre-tax or in Roth for 401ks, 403bs, and governmental 457bs. And then section 606 of Secure 2.0, this just extends a law that's already in place for another 7 years, which allows a deferred benefit plan to use assets from an overfunded plan to pay retiree health and life benefits. So the conditions here are that the benefits, the transfers to pay these benefits don't exceed 1.75% of the plan assets, and the plan needs to be at least 10% overfunded. This is also effective right now, was effective date of enactment, which is December 29th, 2022.
Thank you. And I think all of you will agree that this legislation has done nothing to simplify the retirement plan law. In fact, it has added great complexity to it. We're here to assist you as your needs might arise, and we're trying to stay a step or two ahead of most people in our analysis of the law. Thank you for attending today.
Question.
Just
We have some questions.
2 questions.
For those of you who can stay on, I know we're at the 10 o'clock hour. For those of you who have to drop off, thank you for attending. We will take the questions for those who can remain.
So one of them says, not in the presentation, but related to the Secure Act, for an inherited IRA where the decedent began taking RMDs, is beneficiary RMD calculated based on beneficiary account holder life expectancy and complete distribution at 10th year? I believe, and we've had this discussion before, and the IRS issued regulations in 2022 that went like 275 pages, and I'm not sure it answered the question clearly. I believe that nothing has changed, that where minimum distributions are required over that 10-year period before the balance must come out, that you will have the same choices available to you that you had prior to Secure 1.0. But double check me on this. This has been kind of a hot topic of discussion. We have another. Yeah, one more. Does the employer get a deduction for their Roth contributions if the employee elects that option?
The employer does get a deduction for amounts paid to the employee, whether it's a traditional or a Roth. The issue is whether the employee has to report it as income, how it is shown on a W-2. So it has no effect on the employer's deduction for compensation. That's our last question. Okay, thank you for those who stayed with us an extra few minutes. Absent another piece of legislation, which probably is unlikely in a very divided Congress, we'll be back in September with the first of 2 trios of presentations for accountants and financial professionals. For those of you who prepare tax returns, have an easy tax season. For everybody, happy and healthy New Year to you.